And welcome to the Chapter 11 video lecture. In Chapter 11, we're going to go over what is called authentication, identification, and exhibits. Now, let's go over what that exactly means because those words don't have any meaning unless we really understand what's going on. We have many sources of evidence that come into a trial, as we all know. We have witnesses who testify. When they testify based on their personal knowledge of what they saw, what they heard, and that is good quality evidence that can come in for the purpose of proving whatever it is they heard or they saw. But then we have other things that can also tend to prove things which are not connected with witness testimony, or they're not exactly witness testimony, although sometimes we have to have witness testimony in order to get them into evidence. But these things are typically physical objects, documents, anything essentially that's physical other than a person that we bring into court to prove something. So, for example, we may have the murder weapon in a murder case. We may have the gun. Well, we want to bring that in. We want to show the jury this is how he killed the person. Here's the gun itself. And we want to put that on as evidence. We don't want the jury to wonder, where's this gun? That we say it was there. No, here it is, right here. We may have a DUI case, and we had a blood sample that was taken. Well, let's assume there's a controversy over whether that blood sample that was taken was properly preserved or in fact was properly labeled so that we know that it is from our defendant, not somebody else. Well, we would want to bring in the blood sample itself, believe it or not, and show the jury, here's the blood sample, here's the labeling that was put on the outside of the tube, here's the seal that was placed on the outside of the stopper in the tube, and all this sort of stuff. And so we would actually bring that in. Now, it happens to be that if we're going to bring blood into the courtroom, we're going to have it sealed up so that even if the vial were to break, for instance, they're not going to have blood scattered all over themselves. Actually, I still remember one defense attorney telling me that he was in a DUI case before we did that sort of thing and before we had such a scare over HIV and several other blood-communicated diseases. And he was up in front of the jury waving this test tube of blood, and there was some sort of issue about the test tube of the blood, and you wouldn't believe it, but here comes the cap, comes right off the blood, and he throws it, or it kind of waves it in one direction, and it waves all over. All his blood comes spurting out all over all the jurors, and you can imagine what that did to everyone. And so you can see that sometimes we have to properly deal with these exhibits to make sure that nothing bad can happen to people. For example, also the gun. We don't want that gun to be something that people can hurt themselves with. So what would happen is, in order for the gun to come in, we would actually put a lock mechanism through the barrel, and with a locking, a lock on the outside. So basically, a big wire goes through the barrel of the gun and locks to a lock so that it can't be used as a gun no matter what happens. Similarly, I had a case where one of several exhibits were the actual drugs that were seized by a search warrant on a major case. We had virtually probably $5 million worth of drugs that were sitting on this cart that the poor clerk had to wheel up to the court every day from the evidence locker in the court. We wondered why she didn't get mugged on the way to court, because that was a lot of money worth of drugs. Those kind of things create problems, but we do want to show the jury the drugs. Now, we do not want the jury to be able to actually touch the drugs. Unfortunately, we've actually had situations where the drugs have become missing when they were given to the jury to look at. And so we actually have to sometimes protect the jury from any kind of problems that can come up, or the populace generally. We don't want that gun, for instance, getting out and hurting someone. We don't want drugs getting out into the world, after we've taken them by law enforcement and that sort of thing. Anyway, so we're dealing with physical stuff, essentially. It can be any physical object. It most typically is documents themselves. It can be an audio recording. It can be a video recording. It can be compilations of data, or even just lots of data that has been printed out on a piece of paper, or even contained in a CD-ROM, so that it can be perceived. Now, if we use a CD-ROM to contain all these documents, for instance, then we have to give the jury a computer, of course, to be able to look at the actual documents if they want to look at them. And that's what we do. But more and more now, we don't bring in boxes full of documents in a paper chase kind of case. We bring in the CD of the documents, and then we do the proper authentication and identification of them, which we're going to go through here in a minute. And then they can come on as evidence if they are relevant, just like any other relevant evidence. Now, that's an introduction as to what authentication is, what identification is, because what's important about this concept of authentication and identification of these things we call exhibits, which are physical objects of some sort or another, is that we have to have evidence put on before we can introduce those physical objects into evidence. And that testimony or other evidence has to establish that the thing that we say this stuff is actually what it is. So for instance, if I say, I want to bring on the telephone records from AT&T showing that the defendant made a call on a certain date and time to the victim. Well, I'm going to have to put on evidence that the document itself that I'm bringing on as an exhibit under this concept is in fact the record of telephone calls from the defendant's residence in the operative period of time. I have to actually put on evidence that establishes that before I'm going to be allowed to put on the evidence. And the reason for that, of course, is we just don't let some attorney come up there and say, well, Judge, here's some telephone records, and I claim that they are the appropriate records that I claim them to be, and therefore they come on as evidence. Now, attorneys cannot testify unless they happen to know what the answer to the question is, know what this stuff is that they're bringing on, and be able to testify to it. And by the way, they'll never do that because attorneys cannot testify in a court case in which they are also the attorney. It's against disciplinary rules. It's not allowed. You're going to end up destroying your client's case if you do it anyway, or try to do it, or accidentally put yourself in a position where that happens. So we don't just let an attorney come up and say, oh, Judge, here's the telephone records of the defendant. And the judge says, oh, okay, well, I guess so. They must be because you say they are. No. No, the judge will say, well, that's nice for you to say that, but now you're going to have to prove that they are, because otherwise you're not getting this stuff into evidence. That's very important for you to understand, that we have to authenticate and identify these exhibits. So if we have the murder weapon, and especially if there were fingerprints on the murder weapon, then we're going to have to authenticate that this murder weapon was somehow preserved in such a way, once it was discovered by law enforcement, to preserve the fingerprints that were on it and from being contaminated by just any old person's fingerprints. And so that's part of the authentication process. If we say this gun was collected under circumstances by which the fingerprints would be able to be ascertained from the handgun itself, then we better put on evidence that suggests that whoever found this thing, presumably on the floor, picked it up with a pencil or something else that would not smudge any of the fingerprints, put it in a plastic bag, sealed the bag, labeled the bag as to what it was, kept it in their possession in a locked facility of some sort until it could be analyzed, this kind of stuff, to make sure that no one got in there and tampered with the evidence as well. We'll see that's what's called the chain of custody, which is very important. If we say that something was in fact properly protected, then it better be protected. And when it comes to documents, most documents that we will be introducing as evidence in most cases will require authentication. That is, that we need to prove that these documents are what we say they are. So if these are the documents of AT&T as the telephone records of the defendant's house, then we need some evidence to prove that that's true. It can't just be something that we could perhaps have made up, or maybe it's somebody else's telephone records. No, it has to be good evidence that those documents are what we say they are. That's what authentication is. That's proof that the thing that we're trying to admit into evidence is what we say it is. That means it has not been altered, it has not been modified, it is exactly what we say it is. So that we have to put on proof of that. And so if we were to do that for the AT&T documents, we might bring the custodian of records from AT&T to come on in as a witness and testify that yes, he or she knows, what records AT&T has, and they are the person who has care and custody of those records, and that their job is to be able to go through those records, find the ones that we were subpoenaing, and that yes, what I have in my hand here is in fact the records of the defendant's house, telling what telephone numbers he had been calling during the time period relevant to this action. And that would be good authentication. That's good enough. That's somebody who has personal knowledge of what the documents are. They work for the company, so they obviously could possibly have such personal knowledge. And they can competently testify that what they have in their hand and that we later mark as an exhibit and bring into evidence is in fact the defendant's telephone records during the relevant time. Now, we also have certain kind of documents that are self-authenticating. That means that they are documents that we don't have to put on any evidence to authenticate. These would be certified copies of government documents. These would be newspaper articles, for instance. And that's because we just realized that it's very, very unlikely that people are going to be able to falsify those or to manipulate them or modify them without someone being able to know about it. So, for instance, if we want to put on a newspaper article, we'll see that that's considered self-authenticating, because if it's not what the newspaper article actually was, it's easy for someone to go find out by, asking the newspaper for a copy of their article and comparing what we're trying to introduce, and that makes it real easy. So we don't need, we'll see, to always authenticate, but in most times we will. And then that's what we call authenticating business records, and that's because business records are often used in both civil and criminal cases. And those things, there's an exception to the hearsay rule for business records, as we have already studied. But we still have to authenticate that those are the business records of that company. We also have to set forth evidence showing that those business records meet the requirements of the exception to the hearsay rule as well. So we have to have both authenticating evidence and evidence for the foundation for the exception that establishes that they are in fact business records, and an exception to the hearsay rule before those will come on. But once we do, then they come on as evidence, and then they can be used by the jury for that purpose. All right, so let's look at ancient documents. It just happens to be that ancient documents, these have to actually be physical documents, and it depends on the jurisdiction about how old they have to be. But once they're that old and they have signs indicating that they really are that old, such as, weathered paper, paper that's sort of curling up or changing color, where there's obvious signs that this is an old document and it's more than the requisite number of years old, that can come on as sufficient authentication itself. So it would actually become able to document itself. This is often done when we see things like family Bibles, where someone's heritage has been placed in the Bible, and that's an exception to the hearsay rule. But the way that Bible will come on is because it becomes an ancient document. That means a document that was created more than so many years earlier, and that's just because it's very, very difficult for people to falsify those things. They tend to be very, very reliable, and so we don't need very much to identify those and authenticate them. Also, computer and other technically generated records are another thing. We have to have someone be able to come on and say, yes, these are our computer-generated records. Here's how they are created. And this is what they say, and this is the underlying basis for the records, and so on. And then there's also state statutes and acts of Congress. Those things are basically the law. When we have the law and we want to bring that law into a court, we don't have to authenticate those. We'll see. Those are just because they're so easy for someone to go and check on them as to whether they are in fact statutes of states or acts of Congress, that we can just bring those into court. For instance, it's possible, you can have a court case in New York, but that California law applies. When that happens, we can actually bring in the statutes into the court and say, okay, here's the California statutes that you want to use to decide this case. And that's one thing that comes in with no real need for authentication. And there's also what we call the best evidence rule. We'll see what that is in terms of it. It is an old rule that is basically, for the most part, has been done away with, but you do have to remember some parts of it. And what it is, it used to be that if you were to bring on a document in the old rule, you had to bring on the original document, unless you can explain why the original is no longer in existence. You have to bring on the original. You can't bring on a copy. And the reason for that was because it was very easy to forge the copy or to alter the copy so that it's different than the original. So we had to have the original. Now, based on the you know, wide use of copiers and the fact that it's hard to tell sometimes what is the actual original, except for contracts and wills and things like that, it's no longer appropriate. The only time now where the best evidence rule applies is if there's a true issue as to its authenticity. Meaning the other side says, hey, judge, we think this is a forgery. Here's the reasons why. And the judge says, okay, well then, where's the original? Let's go look for the original. The side who wants to bring it on says, you know what, judge, we don't know where the original is. The only thing we have is a copy. In essence, so you have a little contest about whether you can get on something other than the original when there is a true contest as to believability of whether it's in fact the original or a good copy of the original. And then there's what we call summary of documents. These are called compilations. For instance, you may have hundreds of thousands of pages worth of bank documents in a paper chasing case where you're actually trying to trace where money went as part of, let's say, an embezzlement case. Well, you have to actually get the underlying records from each of these accounts, and it tends to go on forever because what these people who embezzle money will do is they'll try to transfer the money through several different bank accounts as a way to try to hide what they were doing. So you have to go to each of those bank accounts, get the records, bring the records in, and then show how the money went in different directions. Well, you're not going to have the jury do all that work, going through hundreds of thousands of pages worth of documents to find out what the answer is. No, you're going to have someone like an accountant come in and prepare a summary of underlying documents, which we call a compilation. It becomes a compilation of information. And then the compilation of information becomes its own exhibit along with the underlying documents that are also there in case the jury wants to look at them, which they probably won't. But the person who created the summary has to come in and authenticate that it is in fact a summary of those underlying documents. Okay. All right, so let's first look at Federal Rule 901. It says prior to the admission of tangible evidence, that means documents, physical things, videos, photographs, etc., the evidence must be authenticated. That's the general rule. There are exceptions, but that is the general rule. You cannot just bring on something that's a tangible piece of evidence unless you establish that it is what you say it is. That's what the authentication process is. Whenever you see the word authenticated, you can simply put in there the following: proof of the fact that the item is what we say it is. That's what authentication is. So whenever you're talking about something being authenticated, proof is being placed in the court to prove that the thing is what we say it is. And that's what needs to be done. And if you don't do that, you're not going to get that evidence item on. So again, authentication is the process of proving that the thing is what it purports to be and has not been altered or modified. That's the ultimate thing. In essence, if it is what it is, then it better be entirely that. It can't be altered or modified in any way. This means we have to lay a foundation, just like we did for the exceptions to the hearsay rule, to admit these tangible evidence by proving the existence of the authentication, proving that it is in fact what we say it is. And what kind of foundation needs to be done depends on the kind of evidence that you're involved in. Okay. All right. So 901B describes a non-exhaustive list of ways to authenticate physical evidence, including testimony of witnesses who have knowledge of what the original item was, non-expert opinion on handwriting. So you could actually, for instance, authenticate a document as being something from a particular person by someone who can recognize that person's handwriting. If they can, they say, yes, I recognize that letter. The handwriting on it is of John Smith, and so now I can authenticate the letter as coming from John Smith because of that handwriting. Also, comparison by the trier of fact or an expert. So you might bring on an exemplar of handwriting, a known exemplar of the defendant, for instance. And then the trier of fact, which would be the jury or the judge, as the case may be, or possibly an expert, can then compare the signatures and make their own determination as to whether it's authentic. There also can be distinctive characteristics of the item, such as if it's a letter from an academic institution, for instance, we're probably going to see it on letterhead. That may have a very distinctive type of letterhead, and that distinctive characteristic can also authenticate. Also, voice identification. If you're looking for a telephone call, for instance, or a recording of a certain person's voice, you can get someone who knows the person well and knows what their voice sounds like to say, yeah, that's the person. I recognize his voice in this recording, and that's enough to authenticate the recording. Telephone conversations is another one. You do that through this voice identification. You do it through possibly also records as to where the call came from, where it went. If a call comes from somebody's house, most likely it came from that person, that kind of thing. Also, public records and reports can be authenticated, we'll see, actually automatically, because you simply show the certification on the public record, showing that it is a public record. That's sufficient to authenticate it. Then there's the ancient documents, which they become sort of self-authenticating, but actually the reason why they're authenticating by themselves is because of the evidence of what they look like. They show their age, so to speak, and so they come in for that reason. They authenticate for that reason. Then you can also do so through a process or system, so you can actually show, for instance, that we have a system for recording certain information. It gets recorded by a computer. We can access that information anytime we want, and the information that I have in front of me is, in fact, that information that I've been subpoenaed to bring in here, and here it is. That would be sufficient to authenticate that as what it says it is. And methods provided by statute or by some rule would be sufficient as well. And this is not exhaustive. There can be other ways to do it. So as long as it brings on competent evidence the thing is what we say it is, that's sufficient. All right, let's look at some examples. Non-expert opinion on handwriting. You bring in the boss's secretary who knows his signature very well, for instance, or her signature very well. Why? Because the secretary writes up lots of letters for them and then puts those letters into envelopes and sends them out. So he or she is seeing the boss's signature on countless occasions and knows exactly what it looks like. That's good enough. Comparison by the trier of fact. That was we have a handwriting expert or the jury compares the handwriting from a known sample to the handwriting in the document in question. That's sufficient. The jury can say, I think that's the same handwriting, and then use that thing as sufficient authentication to consider the evidence. Also, distinctive characteristics. For instance, I know this ring is mine because it has an inscription, "With all my love, Maria." Well, that's pretty good. That's pretty distinctive stuff. There's a lot of rings out there, but very few of them have this particular set of words exactly as stated, and so that's sufficient distinctive characteristics. Voice identification will be, I recognize the voices on the recorded phone call as my boss and his associate Mark. That would be sufficient. That's testimony. Public records and reports. Please submit the certified copy of the NOAA weather report on the date in question. NOAA, of course, is the National Oceanographic and Atmospheric Administration. They keep reports of weather throughout the United States. And so if you get a certified copy of one of their reports, and if it meets the requirements for the hearsay exception, then that you have sufficient authentication just by the fact that it has a certification stamp on it. Ancient documents. This is our old family Bible with our family tree listed in it. It's a good example. Sometimes those things are often decades old. And even older in some cases, and that's sufficient. All right, the process or system is, I am the custodian of the records for the ABC Oil Company, and I can authenticate these documents because they are regularly kept in our company archives and indexed for easy retrieval, and I went into our archives and retrieved these myself, and so I know these are in fact the records that they say they are. That's good enough. Now the self-authentication is the document speaks for itself in terms of its authenticity. That means neither a witness nor extrinsic evidence is needed to lay the foundation for those kind of documents. That includes public records, which are certified copies. That includes, we'll see later, newspaper articles. A few others, we'll go through those as well. So some documents are in fact self-authenticating just because you look at them, you know that they are authentic. All right, and that's Rule 902. These documents require no extrinsic evidence of authenticity. Domestic public documents, either signed under seal or certified under seal. That's domestic, meaning as in from a public agency of some sort, and they are certified as being records of their agency. Those are authenticated because of the certification alone, and it'll have a seal, and it'll be usually signed by someone as well, and there'll be a certification stamp that's on it, and so on. Foreign public documents that on their face are attested to in an official capacity. That means that we would have a foreign public certification seal on the documents as well. And so if they have a seal that is the seal for that foreign public document agency, then yes, they will come in as authenticated. Certified copies of public records of birth, death, and court proceedings, those are all, again, public records, and they simply have to be certified copies and they can come in. Official publications, those are such things as reports that are required to be published by certain public agencies, and those will come in simply because they are the reports. The reason for that is that if you want to try to modify those things or try to make them up, it's real easy for someone to determine whether they are authentic or not. And so we don't make you go through all the time and trouble to pull some guy in from the agency to actually say, yes, this is one of our publications. All right, newspapers and periodicals, and the reason for that, of course, is that they're very easy to go out and find out whether they are, in fact, the actual articles or not, and if they've been modified or not. So we don't make you come in and bring in the newspaper people saying, oh yes, this is one of our articles and it's authentic. We just don't do that. Trade inscriptions would be such as things like trademarks. Why? Because they are so distinctive. They're out there in the world. They've usually been registered, and they're easy to back up the fact that they are in fact what they say they are. And then acknowledged documents. These are notarized documents. When you have a notarized document, then you don't have to acknowledge. You don't have to put on evidence of its authenticity. Why? Because the notary actually does that, and they're an official public. They're a public person, so to speak. What they do is they actually say, yes, this person came before me and did the following things, such as perhaps they attested to the truthfulness of something, or whatever it is. But what that document is now notarized by a notary who's a public agent who can then say, yes, this person came before me, and this is this person's document that they signed. That's sufficient. And that's very similar to what a public document is as well. Also, commercial paper and related documents, this is checks, notes, bonds, and so on. These things, why? Because they have very distinctive notations on them. If you look at these certificates for bonds and such, they are very, very distinctive. And it was also easy to check up on those. So no, you don't have to authenticate those. Certified domestic business records. There's actually a process now where we allow businesses to send us, as long as the business is not related to the action in any way, they can send us their business records via a written declaration from the custodian attesting to its authenticity and to the foundational facts for the business record exception, the hearsay rule, and they don't even have to come into court anymore. Used to be we'd have to actually bring in the actual custodians. Now we don't have to. If they send this declaration with the proper information on it, attesting under penalty of perjury to the authenticity of the document and its foundational nature for the business records exception of the hearsay rule, those will come on as evidence without anything more. Certified foreign business records also, when they're accompanied by a written declaration of its custodian or other person. So we can actually get a foreign business to bring in their records through the same process. We don't have to bring someone in from Paris, for instance, to testify to the authenticity of records from a French company. All right, now we're going to look at chain of custody. Chain of custody is simply a process of authenticity, or proving authenticity. We call it chain of custody because it is a chain, because what happens is we will sometimes go out and discover a particular piece of physical evidence. That might be the gun for a murder case that we say is the gun that murdered this person. Typically when we found it on the floor of a building, inside of a building somewhere, police are there to find it. There it is. Now, in order for us to prove that that is what we say it is, that is the gun that was found on the floor right after the murder happened, we have to have a police officer come in and testify, yes, I went to the scene of this murder. I noticed someone was bleeding on the floor and eventually died. Right next to him was this gun. Okay, well, then I took that gun and I preserved it as evidence by doing several things. I picked it up with a pencil so I didn't mar any fingerprints that were on it. I put it inside of a plastic bag. I sealed the plastic bag. I labeled it as the gun found at such and such location on such and such date by me, the officer. I then kept that in my possession and did not take my eyes off it until I had placed it into an evidence locker at the police department. Then the person who's now the evidence locker technician will then take custody of it. And so we see a chain coming on. We've got the original police officer. Now we've got the evidence clerk who's keeping custody of it after the police officer gave it up to the evidence locker. Then we have a expert who calls the evidence clerk and says, "I need to get this firearm so I can examine it." And that expert comes by and checks out the item by making up records that say, "I'm here to pick up this item." They also witness the fact that it's still sealed in its plastic bag with a certain writing on it. That they take it, they open the bag up, they do their examination, they put the item back in the bag, they seal it again. They put their own notations on the outside of the bag. They then get the item back to the evidence locker technician, who then continues to keep it secured against any further tampering because it's in the police lockup. And then eventually the investigating officer for the case will end up going to that same evidence clerk. Will say, "I want to bring in all the evidence for this case. Please give it all to me in this box." They put it in a box. The investigating officer keeps all those pieces of evidence, all sealed in their envelopes, in his or her possession until they actually go to the court itself and hand it to the court clerk, where the court clerk then marks it as an exhibit. And that's the end of the chain. So it comes from the original police officer to the evidence clerk, from the evidence clerk to the expert, from the expert back to the evidence clerk, from the evidence clerk to the investigating officer, from the investigating officer to the court clerk. Now, all throughout that process, we have to have good evidence that that chain would give us a reasonable idea that there's been no tampering with the item, and it is the same item as was picked up originally. Not some, not some counterfeit, not something someone's, put in there for us. Now, I want you to look at this on the PowerPoint. You can see there's a link. I want you to look at that link because that's the bloody glove in the O.J. Simpson case, and see how many mistakes that were made by the LA Police Department in the chain of custody of that bloody glove that eventually led to it having no evidentiary value. In fact, it actually had the opposite when it comes to evidentiary value. Okay, so let's look also at authenticating business records. Business records are records in the hands of businesses that we might want to use to prove up something in our case. If we want to get someone's financial records, we go to their bank, that is a business, and we say we want the records of the defendant so we can prove that he was stealing all this money, because all of a sudden this money starts coming into his bank account. Okay. Well, you first have to establish authenticity of the records. The records have to meet the requirements of the business record exception to the hearsay rule under Rule 803.6. And you can establish this in two different ways. You can bring in the custodian to testify to their authenticity and the foundational facts for the hearsay rule exception, or you can use that written declaration from the custodian of records attesting to their authenticity and to the foundational facts for the hearsay rule, which, by the way, 99.9% of the time we are going to use the written declaration. There's no reason to trouble someone from Minnesota to come in to testify to AT&T records or the bank records or whatever, because we've got that written declaration process. And believe me, that's going to be predominantly how we're going to do it. All right, so in a criminal case, if the declaration for business records shows an absence of any records that are requested, this is very important, but only in criminal cases, then the custodian must testify. We may not use the written declaration. The reason for that is you have a right to confront the witnesses against you. And if there is an absence of any record, we ask for, let's say, telephone records for a certain telephone number, and they say, well, no such records exist. That line was shut down, for instance, or there was no such line, perhaps, whatever that is. If there's an absence of records, then the defendant has a right in a criminal case to confront them to find out why there was no record. When there are records, of course, then they would have, if they didn't like what the records had to say, they could bring in the custodian and to refute it if they thought there was some sort of error in the records that made it to the court. But if there is no record, then they have a right to say, well, how closely did you look? Because it might be that it's the defendant asking for these records, and if so, they have a right to find out what these people did to try and find these records, because maybe they do exist and they just didn't look hard enough. All right, ancient documents. Under the federal rules, authentication requires that the document is in a condition as to create no suspicion concerning its authenticity. That means that there can be no viable basis for anyone to say that they think it's not authentic. If there is, then these ancient documents have to be authenticated through their normal methods. But if there's no thing available out there for people to say, oh yes, I think we have suspicion that this might be altered or counterfeited or whatever, then we can use this authentication process for ancient documents. The thing has to be found in a place where, if it was authentic, it would likely be. So if it's the family Bible, we'll likely find it where the family is, in their home, for instance, in a treasured place, probably in a bookshelf somewhere, prominently displayed typically. And then it has to be in existence for 20 years or more at the time it's offered into evidence. And then that's all. You have to have someone say, yes, I found this Bible in the family home. I'd never seen it before, but I found it there. I found it where I expect to find the Bible. You can look at this thing. It's obviously very old. It has, the pages are all brown and wrinkled and round around the edges, and lots of writing had been in there that looks like it's very old, more than 20 years old. Done. That's all you need. That's all you need for authenticity of the ancient documents. Typical examples are the family Bible. Even the decedent's will would be authenticated that way. And family trees, which we often find in family Bibles, are among the type of documents that can be used and put in and authenticated. All right, computers and other records, photographs, documents, videos in digital form need no special authenticity to be established. Meaning not special, but there has to be. So if you have a photograph of something, you have to bring in a witness that says, yes, that's a photograph of the scene of the murder. That's the picture of the gas station at the time that the police were there, right after the murder happened, for instance. You have to have someone to authenticate it in that sense. You have to have someone authenticate a video saying, yes, I've looked at this video, and yes, that is a proper rendition of the location where the murder took place. It was it looked the same at the time that the murder took place, and so on. But otherwise, there's nothing special about authenticating photographs or documents other than the normal stuff. You just have to put on something that would lead the jury to believe reasonably that it is probably what we say it is. Now, however, if it's a process or system that has been imposed on the item, meaning we've done something with it, such as enhancing the photograph, which sometimes happens. You can do that through computer algorithms to enhance its ability to, or your ability to see it. Then we have to have someone come in and say, what did you do to the thing? Because what's happening is it's altering it. Sometimes we have audio recordings that are very hard to hear. Sometimes we have a lot of scratchy noise in the background and so on. And so we will do computer techniques that take out the noise, so we can bring up the background audio much higher without ruining our ears. That kind of thing. So we have to have, if we're going to put a process to one of these visual or audible type of exhibits, then we're going to have proof that the system is reliable, it's accurate to appropriately portray the evidence in the item as it originally was, and if not, you're not bringing it on, because otherwise it's altering it. Okay. All right, the best evidence rule. Best evidence rule is an older rule. It's pretty much not there anymore, but we do have to know about it because it does bring up its ugly head every once in a while. It requires that the proponent of the evidence, that's the person who wants to bring in the evidence item itself, use the best evidence available. Now, there are many exceptions to the rule, and it's almost been eaten up entirely. Because a duplicate now is admissible as the original unless there's a genuine issue of authenticity. If someone says, you know what, Judge, we think this is a fake, and this whole case, rides on this document being authentic, we think it's a fake, the judge is going to say, okay, well, Mr. Proponent of the evidence, where is the original? And if you can't explain why that original isn't around, or you can't get your hands on it, you might not get your evidence on, based on this best evidence rule. But vast majority of the time, we don't have problems with authenticity, and therefore we don't have to worry about the best evidence rule. But if there is a genuine issue of authenticity, it's going to raise its ugly head. So if a document is no longer available even as a copy, then and only then can we have testimony as to the contents of the document, because the best evidence rule also says that documents speak for themselves. You cannot have someone testify as to what's in the document when it's a written document. It speaks for itself. And so the only way you could have someone say, yes, I remember what the contract said, is when the contract's no longer available. You don't even have a copy of it anywhere. It's just long gone. But it did exist at one time. This could also be for wills, although unusual if it would be for wills. But you could say what was in a will, because I read it. Maybe I composed it, that kind of thing. But we don't let people actually testify as to what's in documents because they speak for themselves. All right, so compilations of documents. These are where we take lots of, let's say, business records, let's say of many financial records, bank account records, checking account records, savings account records, for many different bank accounts throughout the entire country having to do with a scheme to embezzle money. And we have to, you essentially access thousands and thousands and thousands of pages worth of financial documents to get the actual information that we need. Well, we're not going to make the jury go through all that. We're going to create a summary, but we're going to have an expert, someone who's like an accountant type, go through the original documents, create the summary or compilation, we call it, of information that's the pertinent information from the business records, put it together in an organized form in a very small little summary, and then we're going to admit that summary under Rule 1006. We're going to actually admit the summary, and that will be authenticated by the expert, him or herself. And then we don't necessarily have to bring in the underlying evidence if we don't want to, but typically we will, so that no one ever has any doubt that this is an authentic summary of what's in the documents. You may have boxes and boxes worth of documents. So the jury will never go through them. They're not going to do all that work. But the fact that it's there gives them some assurance that if there was a problem, the other side would have the opportunity to point it out. And so that's why we typically will actually bring in that evidence, even if no one's ever going to look at it. Let's look at an example of that. This is actually a case that I did in it was an embezzlement case by an attorney. He had taken half of a settlement that he had gotten for the client. This is Betty Moran, was her name. The name of the defendant was Alan Courtney. He's no longer an attorney because he got convicted. He took in this $205,000, which was half of a settlement, and put it into his trust account. Everything's good so far. Then he takes a good hunk of that and puts it into the Valley Oaks Bank in trust for her. Everything good so far because he's just holding it in trust for her. It's still her money. He also pays some of her expenses, which she authorized to do, which is not a problem. He paid money to Anita Kohler for her expenses. And then all of a sudden, after he put the money in trust in this Valley Oaks Bank, he started to pull it out and give it away. First, he paid a Castle Hill retirement home bill, which was legitimate. Then later in the month of July of 2003, he started making these checks out to his son, put it in his son's grandchildren trust, put it into his daughter's grandchildren trust, put it into $11,000 into his other son's grandchildren trust. He gave himself a gift of $11,000, gave his wife a gift of $11,000, and then he gave $47,000 to his law office, which he did not earn. And then he gave the rest, $85,000, to Nancy Moran by sending her a check. So out of the $205,000, after paying a few bills, she gets $85,000. And about $16,000 of that should have been paid to someone else. The rest of it was all stolen. But we had to actually get the law office of Alan Courtney bank accounts at Valley Oaks Bank. And we had to get all the records for the Valley Oaks Bank trust account where he was holding money for this client, and then and accumulate all that information, which was several thousands of pages of documents. Instead, we could put it all together, and here it is. It's sitting in a nice little compilation. This is what happened on this day. He took in $205,000. He paid out these amounts during these times to these particular people. All done. Very nice little neat package. Jury doesn't have to go through thousands of records. It's all there. All right, that's it for authentication, identification, and exhibits. So if you have any questions, again, please feel free to give me a call.